There is one matter of 2017, very old matter. But I pray to your lordship, just give me one evening. Last night I sat with the file, my lord, departmental proceeding of bank employee. I could not complete, my lord. I want one evening, my lord. So that I can assist your lordship.
Which item? Which item?
Item number, my lord, 17 matter, my lord. I should not have mentioned, but I want one evening.
Take down on the request of Mr. M. Nath, Lalit Senior Counsel appearing for the petition,
Day after tomorrow I can do it.
citing personal difficulties. This matter be posted for hearing again day after tomorrow. That is, give the date.
My lord, I would like to mention this matter for listing, my lord. It was last listed on 8/5 and the 2023 matter, my lord.
What is the matter?
Matter, my lord, my lord, we are the master role employee, my lord. We are seeking the minimum pay, my lord. But that is not given, my lord.
When you want it?
My lord, any date, tomorrow or
Next week.
next week.
May I please, I beg to mention for listing my motion matter on Friday, my lord. Matter relates to non-payment of pension, my lord. Okay.
My lord, with the consent of the petitioners council, I beg to mention item number 10, my lord. It's a hearing matter, the discharge from service for reading entry, my lord. So, my lord, last occasion, my lord, R. Majumdar raised the question, my lord, that since 2019, reading entry in 2019, 2021, the department waited. So, I want that to verify the record is necessary, my lord. I have discussed with the R. Majumdar, my lord, the issue, my lord. So, my lord, to call for the record, my lord, at least 2 weeks time, my lord.
Where is Mr. Majumdar?
Majumdar,
On behalf of me, lordship.
Take down in item 10, Mr. K.K. Parasar, Lalit CGC appearing for the respondent submits that for conducting the final hearing of this matter, departmental records would be necessary, which is not presently available with him. Stop. As such, a request has been made to post this case for hearing again after 2 weeks, so as to enable him to obtain the records. The prayer is not opposed by Mr. R. Majumdar, Learned Counsel for the petitioner. In view of the above, hearing of this matter stands adjourned. Registry to list this case again after 2 weeks.
I am obliged.
May it please your lordship. Lordship, I beg to mention for listing a motion for tomorrow, lordship. Motion, lordship. Oblige, your lordship.
May it please your lordship, my lord, this matter was fixed on 18/6, my lord, but has not been listed. The matter relates to the dismissal from service, so in the next week on Monday.
Lordship, praying for listing this for motion, Lordship, tomorrow or Friday, Lordship.
Friday?
Friday. Always, Lordship.
Lordship, I pray for listing this matter for orders, Lordship, on Friday or next week, Lordship, anything. Friday,
Next week.
next week, Lordship.
Lordship, may I pray for listing of a matter for hearing, lordship, for final hearing, lordship, next week, lordship.
Final hearing, you can't get it by mention. It has to be listed for orders. Orders, you write orders. Next week, orders.
I beg to mention for listing the IA for Uddal, my lord, double visit, Thursday, my lord.
Tomorrow.
Uddal,
Tomorrow.
for Uddal, my lord.
Tomorrow.
Yes, ma'am. I am praying for a listing for a hearing, my lord. This matter was listed in 2023 January. That is not listed.
By mention, direct, it cannot be posted for hearing. Can you mention for orders? We'll fix the
Then,
date.
my lord. And next week I will give a date for orders, my lord. Obliged.
May I please, your lordship? This is a matter of non-consideration for promotion, my lord, to the post of superintendent of the food and civil supplies, my lord. My juniors were promoted, my lord. Leaving me, they have filed an affidavit, my lord, wherein the ground cited is non-ability of ACRs and APRs, promotion could not be made, my lord. Lordship, may I kindly see the record of the at page running page 57, my lord. This is the minutes of the selection committee meeting, my lord, held on 26/2/2019, my lord.
Yes.
Lordship, may kindly see the vacancy position, my lord. On 2016, there is one vacancy. 2017 1, my lord. 2018 6, 2019 17. Total number of vacancies is 25, my lord. Hereafter,
Page
filled up,
number?
my lord,
You are referring to page number?
page number 57, my lord, the running page, my. It's a
Ah.
minutes of the meeting of the departmental promotion.
Here it is 58. So what is the post?
It's a from inspector to superintendent of food and civil supply, my. I am a SC candidate, my.
Now, what is the criteria for promotion?
Criteria for promotion is selection shall be based on merit and suitability in all respect with due regard to seniority and to the following aspects of the candidate: personality, character, tag, integrity, previous record, etc., etc. This
Where
is
it?
this.
Where? It's not a part of the record.
This is rule, my lord. I am quoting the rule, my lord, in the writ petition.
What is the name of the rule?
This is Assam Food and Civil Supplies and Consumer Affairs. I am quoting it, my lord, in the writ petition also. The Assam Food and Civil Supply Service Rule 1970, my lord. Rule 13, my lord. In every case where a junior member in the cadre is selected in preference to his senior, in that cadre, the committee shall record in writing the reasons of such supersessions, my lord. There is no such reasons has been recorded in the minutes of the meetings. Only reason is cited that the remaining post has not been filled up due to want of ACRs and APRs. There should not be a ground, my lord, for non-consideration of promotion. That is my case, simple case, my lord.
Where is the gradation list? Gradation list.
Gradation list is page 18 onwards, my lord. From 18 onwards, my lord, in the writ petition. Petitioner's name is at serial number 36, while the name of the private restaurant 5, 6, 7 are shown at 39, 54 and 72, my lord. (36) Mr. Robindra Dega, 54 Mr. Ojit Kutum, 73 Alokesh Das, and 39, my lord, Ranjit Kumar Bhattacharya. Respondent on 5, 6, and 7.
They were promoted when?
They are promoted by on 7th of March 2019. It is at page 28, my lord. This is the promotion order. 21 number of inspectors were promoted, my lord. 7th of March 2019, page 28, my lord.
And where are the names of the candidates in serial number 57, 39, 57 and 72?
29.
39, 57 and 72.
I am not following you, lordship.
Where are those candidates in this promotion order at serial 39?
Oh, my lord. My lord, it is 12, 19, 20 and 21. Ranjit Kumar Bhattacharya at serial 19, Ajit Kutuman 20, and Alokesh Das is 21, my lord.
And what have they stated in the affidavit?
Their affidavit, Lordship, my affidavit on opposition is page 31, is running page, my lord. Lordship may see, kindly see para 9, my lord. As page 33, my lord. Running page. Para 9, may I read, my?
Yes.
With regard to the statement, Mera para 12 and 13 of the writ petition, deponent begs to state that promotion of the petitioner are not considered by selection that deemed to inadequate ACR in respect of the petitioner at the time of meeting of the Department and Selection Committee dated 26/2019. However, the DP drawn against the petitioner was not finalized till the date of holding the meeting of the Department Selection Committee. In this connection, it is further informed that the petitioner is recommended for selection to the post of superintendent by the Department and Selection Committee in a meeting on 8/10/2030, which is kept under seal cover due to pending departmental proceeding and was later promoted to superintendent vice later on 19/8/21, my lord. With respect active effect from 7/11/20. He was further promoted to the assistant director on such and such date. So consider the reason cited is ground cited due to inadequate ACR in respect of the petitioner at the time of meeting of the Departmental Selection Committee on 26/2019. This is the ground, my lord.
Yes, that's okay. There was a DP pending against your client.
My lord, they should resort to seal cover if its DP is pending.
But you also did not come to the court. How can they resort to seal cover of 2019 proceeding now?
No, my lord, they have to record the reason as per the rule.
Mr. Bhattacharya, please answer the queries. If you don't understand, then I'll hear you and dictate the order. There was a departmental proceeding pending against your client
My lord,
when that particular DPC was held.
my
That
lord.
was held in which
It's correct, my lord.
which date? Let us see the date.
26
26 of
to 2019, my lord.
26 to 2019.
My lord,
So at that stage,
my lord,
they should have kept your consideration in seal cover.
my lord,
They did not do it.
my lord.
You also did not agitate that point.
I am hesitating that point, my lord. My writ petition
Oh,
is there.
now you are agitating. At that time, you did not do it.
No, my writ petition is there, my lord. There is an additional affidavit to the writ petition, my lord. When I come to know,
Hmm.
I have hesitated that point.
And there was no interim order passed by the court.
No, my lord. According to the rule, they
There
ought
was
to have,
interim order, later on it was vacated, lordship.
there is an interim order, my lord. But that
Initially,
was
lord.
vacated
Let us-
subsequently.
Let us see why it was vacated. Interim order was to keep his candidature in seal cover. Why it was vacated then? By which order it has been vacated?
There is an interim order, my lord.
Oh, Mr. Bhattacharya, give us the dates. You are. What is the date of the interim order?
29/3/2019, my lord.
Easy.
So it's a seniority dispute today.
Yes,
It
lordship.
is a seniority dispute. Petitioner is the assistant director.
Lordship. Later on, he was,
Where is the gradation list of assistant director? Nobody is prepared, it seems.
Assistant director is subsequent event.
yes, lord.
That's correct. What is the gradation list of assistant director? Are the private respondents shown to be senior to him?
No, they have to show it, my lord. I remain junior, my lord.
Assistant Director gradation list is not with us, Lordship. This was the earlier one, Lordship, by which he was promoted.
This interim order is nothing. It says it will be subject to
Regularize the-
result of the petition.
Yes, Lordship,
Yes.
but all have retired, Lordship. The private respondents, the
Private
petitioner
respondents
also.
prayed before this honorable court, they are going to retire within 6 months.
Mm.
So the honorable court has vacated the order.
Nothing can be done in this.
Because for this interim order, their the appointment was promotion was not confirmed.
So now everybody has retired. Petitioner has
Yes,
also
Lordship.
retired.
This is the-
Petitioner has not retired.
I put a responsible I on return on 31st of January.
You are appearing for the private respondent. All the three private respondents.
I put a responsible.
Who is appearing for 5 and 6?
You can-
5 and 6 are in service.
J. Payeng, no, they have retired, I have come to know, Lordship.
And number 7, he is also retired.
Is 20.
Hmm.
Serial number 72. Retired on 31/01/2020.
So what is the live issue here?
A live issue is that, my lord, if I get the promotional effect from that date,
Hmm.
according to my prayer, my lord,
Hmm.
I could have some derive some benefit
That can't be given to you.
from 3 if my at that time on 26/2, my lord,
Hmm.
if my promotion was considered at that time,
Hmm.
or if non-considered with reasons, my lord, that will do. If
No,
it
that-
is
that cannot be
considered,
done. That cannot be done.
if it is considered, my lord,
Hmm.
there may be some promotional benefit to me for 2 years. For without any reasons, my service has been taken up without any reason for 2 years, my lord.
Yes, but you, at that point of time, you did not get any relief from the court.
My lord, I have agitated the point before the
But
dishonorable
the court did
court.
not give you.
But court is taken up the matter today, my lord.
All right. You argue, we'll pass the order. You argue. Mr. Bhattacharya's service jurisprudence is like mathematics. You cannot handle it by emotion. Your client
It is
was,
nothing emotional, my lord.
Yes,
It
your
is
client
nothing
was-
emotional.
your client was not considered by the DPC of
And
2019.
they have to give reasons, my lord. They have, without any reasons, my promotion
All
was
right,
not
don't give him
considered.
seniority, just give him the reason. That's all. He'll submit a representation. What is the
Okay.
reason? And you give him the reason.
Lordship.
Reason is clear in the order that the ACR was not complete because there was a
That cannot be a reason, my lord. Without having not ACRs and APRs is not at all a ground for not
not
consideration
having
of
no,
promotion.
because there was a DP pending.
DP pending, if the DP is pending, they should have resort to the seal cover procedure.
That's right. So why didn't you get an order from the court? If the court did not give you, why didn't you file an appeal?
Court has given, my lord.
What, where
Interim
is,
order was
where is the
given.
order to consider your case in seal cover? Where is it? Show me the order.
Seal cover procedure ought to have been adopted, my lord.
Where is the order from the court to do that? Where
There
the
is
order?
no order from the court, my lord.
Complete your order.
I leave you to the, your
There is
honor, my
nothing to
lord.
leave. You argue. Convince the court.
If it is not inclined to give relief, my lord,
You cannot get relief. Not.
I am entitled for a relief.
You argue, then convince the court. Merely by saying I am entitled will not be enough.
I am entitled to give, because the state level selection committee has not cited any reasons for non-consideration of
We'll
it.
ask them to give you the reason. That's all. The reason may be good, bad.
How it is after 5 years, it is a 2019 petition, my lord.
All right.
Now after 5 years, court has taken up it down and my the relief has been
File a
denied.
writ petition against the court then.
No, my lord, I am not, this is the process of the court, my lord. Nothing doing, my lord. I leave it to the lordship, my lord. Lordship may do whatever order lordship may pass. Deem fit and proper.
Mr. Bhattacharya, we are, you know, do you have an option not to leave it to the court? Can you say that I don't leave it to the court? The court will always do what is to be done.
My lord.
We are asking you.
It is the discussion of the
show
court, my lord.
Show the legal provision by
It
which,
is 226 petition, my lord.
so anything can be done. Show me a citation which permits the or relief you are asking.
Man, when a departmental proceeding is pending, my lord, is Janaki Raman's case also. Where the departmental proceeding is pending, the recommendation should be kept in a seal cover. And when the
You're right on that. You're right.
They
But you did not
they
get
should
that
be
order.
resorted to the seal cover, my lord.
They should have done
In
it.
that case, they should have cited that
Correct.
reasons in the minutes of the
You're
meeting.
right on that.
That
That
has
is-
not been done.
But now can we direct them to keep it in seal cover? Your case is that since you have not,
For that reason, is it not bad, my lord?
all right, you conclude your arguments.
This is my simple argument, my lord.
All right. Yes, what do you have to say?
Lordship, first reason is that lordship that at that point of time, as part of our affidavit lordship, the DP was pending and as such, and the ACR and APR lordship of the petitioner was incomplete during that time, lord. The APR has to be, though it is not included lordship, as per the rule, APR has to be provided by the.
So
petitioner.
that's right.
Yes,
You should have kept his case in seal cover.
Lordship.
But the problem is that stage has gone now. It cannot be undone. He has missed the bus. You will not agree, but he has missed the bus. Had he got that order from the court to keep it in seal cover, then we could have connected his promotion to that DPC. But he got the promotion through the subsequent DPC. There is no law in this earth which permits that DPCs of 20 give effect to the promotion from 19. That is not permissible under the law. That is why we cannot give him that relief. He will not agree, but no law, legal fiction permits that. The promotion cannot be from an anterior date to the DPC, except if it is shown that the DPC itself was wrongly conducted. It is not his case that DPC has been wrongly conducted. It is his case that they should have kept it in seal cover in 19. That's correct. He is right. But somehow the court did not give him that relief. He did not challenge it. The court only says it will be provisional. So provisional promotion will be provisional, but then these people have retired already. So what is the meaning of provisional now? If they were in service and if it was a live issue, then we could have clarified. But they have retired. So what he wants is my promotion given in 2020 should be counted from 2009. That is not permissible under service rules. That cannot be done. That will create a huge problem for the finance, for the AG. So it is only for this reason that the court is taking this view. Otherwise, not because we have done it right. Had he got that order seal covered, he would have made it. Pendency of DP is nothing but only a ground for seal cover. You have not considered him. But the problem is the clock cannot be set back now. So what to do?
Lordship, he has been only, he has been given his due promotion and everything, lordship, on the next DPC lordship.
That's right. He wants retrospective benefit of a promotion which was not given to him.
2019 DPC lordship.
Yes. He wants antedating of his promotion. That cannot be done. Anyway, you are appearing for whom?
Lordship for the department.
No, don't say department. Give us the,
1, 2, 3. 1, 2, 3.
one, two, three.
Sure.
And what about 4? You are appearing. 5, 6 absence and 7. What do you have to say?
uh, and, was very low, so the DPR was very. That's why our case was considered. I have put a, unreserved can be.
He is not claiming any relief directly against you. Where is the minutes?
But our promotion was not regularized. That's why.
No, that is another matter. We are not
that's
going.
why
into that.
I was fine, and thereafter this temporary motor was. Even
So later on, promotion was regularized.
the motor was 1/9/2020. Last one, April 21.
Where is the minutes of the DPC page number?
Lordship, these are, I have the copies, Lordship.
No, in the writ petition, which
In the
page?
It was selected.
They have not, Lordship.
Huh?
Was
It's
selected.
just-
No, it is not a part of the record. No, but he has shown just now the
No, it
DPC.
is a part of the record, my lord.
Yes.
Subsequently, Lordship.
They have given it, I have annexed it my in affidavit in reply, my lord. That's page 59,
Lordship has directed.
58.
Got that.
57, my. They
Okay,
produced it before the honorable court.
all right.
I have
These minutes are also not under challenge.
No, Lord.
Minutes are not under challenge.
No, Lordship, this is not.
Mr. Bhattacharjee, this minutes of the meeting held on 26/2/2019, is it under challenge in this writ petition?
No, my lord, it is not available at that time. Subsequently, they have submitted. reports. My simple case is that my junior was
Yes,
promoted,
yes.
superseding me, bypassing by violating the service rule. my lord. At that, 2019, my lord. If they have some departmental person, they have to resort to the chill cover person. So that is, without any reason, my promotion was, my juniors were promoted. DPC has not cited any reason, but according to Rule 13, they have to cite some reasons. This is not a reasons, my lord. And I will.
So we'll set aside your promotion and ask them to consider a fresh from inspector to superintendent.
Do that, my lord.
Huh?
Lordship is free to do everything, my lord.
Mr.
If at least
Bhattacharjee, you seem to
a
be-
clock may be, Lordship is just now saying that the clock may not be reversed. But you can reverse it now. Oblige, my lord.
Is that your, are you taking a reserve?
No, my lord, I have every respect to the honorable court. I have heavy respect to this honorable court. I have nothing against the court. I just by submission, I am putting my case of my client. My lord. If anyway I am hurt your lordship, I am apologizing for it. I am not, it is not intention to hurt your lordship, my lord.
Take down. Heard Mr. D.N. Bhattacharya, learned counsel appearing for the writ petitioner. Also heard Ms. M. Bhattacharya, learned additional senior government advocate Assam, appearing 1, 2, 3. Ms. B. Bora, P. Sharma for respondent number 5 and 6 is not present. 7, Mr. M. Kalita. This writ petition has been filed with a prayer. Inter alia with a prayer to consider the case of the petitioner for promotion to the post of superintendent, food and civil supplies, food, civil supplies and consumer affairs department with effect from 7/3/2019. And also to set aside the promotion given to his juniors, that is respondent numbers 5, 6 and 7 by to the post of superintendent by ignoring the case of the petitioner, although he was senior in the gradation list. Stop. It appears that On 26/2/2019, the Departmental Selection Committee headed by the Secretary to the Government of Assam, Food, Civil Supplies and Consumer Affairs Department, Dispute, had met for considering the case of eligible departmental candidates serving as inspector for promotion to the post of superintendent in accordance with the provisions of Rule 9, 12 and 13 of the Assam Assam bracket Food and Civil Supplies bracket close Service Rules 1970. First of all, according to the petitioner, his name appeared in serial number 36 of the gradation list of Inspector of Food and Civil Supplies circulated by the departmental authority on 21/2/2019, and therefore he was within the zone of consideration for promotion to the next higher post of superintendent as per Rule 13 of the Rules of 1970. However, without assigning any reason, the DPC had ignored his candidature and went on to recommend the promotion of his juniors, that is the private respondents, to the post of superintendent in the department. Full stop. Hence this petition. Stop. By referring to the materials available on record, Mr. D.M. Bhattacharya, learned counsel for the writ petitioner, has argued that no reason, whatsoever, has been cited by the DPC for not considering the case of the petitioner. Stop. Therefore, although his client was subsequently promoted to the post of superintendent on on 8/10/2020, yet he became junior to the private respondents and had also missed out on the promotion with effect from the date on which his juniors were promoted. Full stop. According to Mr. Bhattacharya, even if it is assumed that the candidature of the petitioner was not considered by the DPC meeting held on 26/2/2019 due to pendency of departmental proceeding, yet it was incumbent upon the department to consider the case of the petitioner in a seal cover, awaiting the outcome of the departmental proceeding, which has apparently not been done in the present case. As such, submits Mr. Bhattacharya, there has been flagrant violation of not only the relevant provisions of the rules, but also fundamental and legal right of the petitioner, leading to his deprivation of promotion from an anterior date. Full stop. Next, responding to the above arguments, Ms. M. Bhattacharya, learned additional senior government advocate Assam, has argued that the reason as to why the petitioner's case would not be considered by the DPC held in the year 2019 has been demonstrated in the counter affidavit filed on behalf of the respondent numbers 1 and 2, which is pendency of departmental proceeding and non-availability of complete SCR. Ms. Bhattacharya submits that the petitioner has not only failed to assail the DPC minutes dated 26 to 2019 in the present writ petition, but he has also failed to demonstrate as to in what manner the promotion given to the petitioner in the year 2020 can now be interfered with so as to grant relief to the writ petitioner. It is also the submission of Ms. Bhattacharya that the private respondent numbers 5 to 7 against whom the petitioner is claiming seniority have already retired from service on attaining the age of superannuation. Therefore, no live issue survives in this proceeding at this stage. More particularly, the petitioner has in the meantime been promoted to the post of Assistant Director from our Food, Civil Supplies and Consumer Affairs. Ms. P. Sharma, learned SC, APSC, appearing for the respondent number 4, has adopted the submissions of the learned Government Advocate Assam. Mr. M. Kalita, learned counsel for the respondent number 7, has also argued that since his client has already retired from service, he does not have any further submission to make in this case. I have considered the arguments made at the bar and have also gone through the materials available on that. There is no doubt or dispute about the fact that the conditions of service of the writ petitioner herein is governed by the provisions of the service rules of 1970. Rule 13 bracket numerical 2 lays down that selection for the purpose of promotion is to be made on the basis of merit and suitability in all respects with due regard to seniority with reference to the criteria laid down therein. There is also no dispute about the fact that the writ petitioner herein was senior to the private respondents in the gradation list of inspectors circulated in the year 2019. However, the petitioner has not denied that at the time when the DPC meeting dated 26 to 2019 was held, there was a departmental proceeding pending against the petitioner. The respondents have stated the reason for not considering the case of the petitioner by filing counter affidavit. Averments made in para 9 of the counter affidavit are relevant and therefore is being reproduced herein below for ready reference. Double tick to double tick. It is no doubt correct that when the DPC dated 26 to 2019 was held, it was incumbent upon the departmental authorities to keep the case of the petitioner in a seal cover, to consider the case of the petitioner for promotion to the post of superintendent in a seal cover, awaiting the outcome of the DP. However, as has been noticed herein above, the same was not done in the present case. The writ petitioner had approached this court by filing the present writ petition at the relevant point of time. However, here also, no interim order was passed by this court protecting the interest of the petitioner insofar as seal cover proceeding is concerned. The interim order dated 20 9/3/2019 merely mentions that the promotion of juniors to the petitioner would be provisional and subject to the outcome of the writ petition. Full stop. From the above, it is apparent that the interim order was merely to protect the seniority of the petitioner and not connected with the date on which the promotion of the petitioner ought to be given effect to. Full stop. Subsequently, by the order dated 5/6/2024, by which order it was vacated?
21/9/2020.
Subsequently, by the order dated 21/9/2023, passed by this court in IA bracket C bracket close number 2169 of 2023, arising out of WPC number 1760. The interim order dated 29/3/2019 was vacated. By the learned single judge, whereafter the promotion given to the private respondents were regularized. All the three private respondents have in the meantime retired. Full stop. The petitioner is continuing in service in the post of Assistant Director. Full stop. The moot question, no, the core question that would arise in the present case is as to whether the writ petitioner having accepted his promotion given to the rank of superintendent with effect from 8/2020 and having failed to challenge the 8/10/2020 and having failed to challenge the resolution dated 26/2/2019 as well as the order of promotion given to his juniors by notification dated 7/3/2019. The relief as prayed for by the petitioner, namely to give effect to his promotion with effect from 7/3/2019, can be granted by this court in the present proceeding. Full stop. The answer to the said question clearly has to be in the negative. Full stop. Since the petitioner was not at all considered by the DPC held on 26/2/2019, directing the respondents to consider his case to give effect to his promotion to the rank of superintendent based on the recommendation of the DPC dated 26/2/2019 would not arise in the eyes of law. Full stop. If the petitioner was serious about protecting his interest by keeping the consideration of his case under seal cover, then it was incumbent upon the petitioner to obtain a favorable interim order to that effect from this court, which he has failed to do so. Full stop. Under the circumstances, I find force in the submission of Ms. Bhattacharya that no live issue survives for decision by this court in the present proceeding. Stop. At this distant point of time, the clock cannot be set back, nor can the petitioner be given seniority above the respondent numbers 5, 6, and 7, who have already retired from service. For the reasons stated herein above, this petition is held to be devoid of any merit. Same is accordingly dismissed.
Oblige me.
May it please your lordship.
Yes.
Lord, I joined as a junior assistant in the Assam State Development Corporation for OBC
What is the
Limited.
matter about? What is the
It's a
matter?
matter of promotion, my lord.
Promotion.
The nutshell is this, my lord, that in 2000, in the year 2000, there was a DP and I was punished. The penalty was stoppage of 3 increments with cumulative effect. The effect has been finished in 2004. In 2019, there are some promotions and all my juniors were promoted, only leaving me. The grounds that and thereafter I am before this honorable court. And the affidavit, they said, since my 3 installments were, 3 increments were reduced with cumulative effect, I became the junior. My seniority has been gone down. That is, they have said on affidavit. And this is the moot issues that your lordship has to adjudicate on.
You are appearing.
Yes, ma'am. There is another issue also. I think I thought my.
No, but another issue that here is a DP. That DP, I was punished. I did not challenge it.
And then third issue, ma'am, there is third leg also. So third leg,
Total, how many issues?
my lord, that is what my lord, I thought my friend will like. And do this.
No, I'm saying the
No,
nutshell.
he will do it, but stoppage of increment means he becomes junior. Is
Yes.
that,
Yes, ma'am.
where do you invent these service rules from? Huh? What has stoppage of increment got to do with seniority? Increment is connected with seniority.
My lord,
All right, let him finish. Let him
in
finish.
2019, he gave a representation before the board. That was also my lord declined. That is also not under challenge, my lord.
Oh,
That we'll see. Yes.
My lordship may come to page 16. This is the first
Page 16.
16, 1/6 of the petition. That is the punishment order. The relevant portion is the second paragraph from the below, from the bottom below. In view of the above, on careful consideration and perusal of the records, and having regard to the evidence and circumstances appearing in the case as well as the submission of the DO as stated above, and after agreeing to the findings of the inquiry officer, the undersigned has decided to inflict punishment under Rule 7(2) of the Assam Services Discipline and Appeal Rules 1964 by withholding 3 increment with cumulative effect. Inflicting of this punishment does not anyway absolve the delinquent officer the responsibility of paying both the defalcated amount of rupees 56,000 to the corporation, which the delinquent officer will require to pay back into more than 36 equal installment or in less than simple interest of 5% per annum for the date of the suspension till final recovery is made. The DO Sri Dilip Kumar Soikia is also reinstated in service as junior assistant in the corporation. The period of suspension of Sri Soikia, except the first 3 months from the date of suspension, shall be treated as on duty. Copy of this order. This is the punishment. And this punishment came to an end after 3 years. Because there are 3 increments withholding and with cumulative effect. So after that, I am earning the increments. That is, these things are not an issue. My lord, then my lord will kindly examine the gradation list at page 32, my lord.
Yes.
Gradation list at page 32. They said in affidavit that I became junior, but in 2009, this is the gradation list of 2019. As I can see, my lord, at page 31, my lord, there is a list notified on 12th February 2019 and my name is at serial number 3. And person at serial number 1 has already retired. And my date of, there are 3 persons on the same, 2 persons on the same date who joined as junior assistant. That is Dilip Kumar Soikia and Satish Chandra Das. Date of joining 30 July 1990, 30 July 1990. And Selimuddin Ahmed, he joined in 31 July 1990. Means only Satish Chandra Das is the person who joined on the same date. But so far as date of birth is concerned, I'm elder to him. I'm a graduate, and Satish Chandra Das is a pre-university pass, a high secondary pass. Now, my lord, will come to the rules, my lord. Recruitment rules at my lord, page 19. Superintendent, my lord. Appointment to the post of superintendent may be made by the appointing authority by promotion on the basis of seniority cum merit from amongst the senior assistant accountant of the office who have rendered not less than 3 years of service as senior assistant accountant on the first day of year in which the selection for promotion is made. Then post of senior assistant. Appointment to the post of senior assistant shall be made by the following methods: by promotion on a basis of seniority cum merit amongst the junior assistant and typist who has head of junior assistant of head office or divisional office who have rendered not less than 4 years of continuous service as junior assistant cum typist on the first day of the year in which the promotions are considered. I am on the date of the promotion, my lord, I am entitled to this post, senior assistant, because I was junior assistant. I joined in the year 1990. 30 July 1990, I joined. So, and so far as qualification is concerned, I'm entitled to, because I have already passed 4 years of service. Now, my lord, the next page your lordship will see the accountant, post of accountant. Appointment to the post of accountant shall be made by the appointing authority the following methods: for selection from amongst employees of the corporation who have passed BCom examination with advanced accountancy and who had rendered not less than 7 years of service. This rules has been flouted by promoting Mr. Amitav Nath to the post of accountant, and to this immediately after 34 days, he has been promoted to the post of superintendent.
Is he a party to this proceeding?
All are party.
Who is appearing for him?
My lord, we have served them notice, my lord, and the affidavit is at, my lord, flag A and B that your lordship can see. None of them have appeared. No personal, private respondents, none of them have appeared. They have served. We filed an affidavit that is flag B and C, my lord.
Hello, may I make a clear matter? My lord, let this matter may come up next week. Because so many people are affected, I will talk to the MD, let any council appear.
Okay.
No, if notice has been served, what is?
4 years, my lord, not yesterday's case.
If they receive notice, then yes, they will be affected. What can be done?
Fine.
Court proceedings cannot be taken so lightly. If he makes out a case, we'll set aside their promotion.
And the first order was that only that their promotion will be.
Just a minute, just a minute.
Everybody have signed, my lord. Kindly see the annexes to the affidavits.
Because everybody is my employees, my lord. He, even that is why, my lord.
No, but no steps were registered, Eddie.
The order was not like that, my lord.
It is time we hold some seminars Dusty service is not a proper service for final disposal. Nothing can be done. You must know it. Point it out to the court.
And on.
Point it out to the court.
I
There is
understand.
no procedure of dusty service in CPC. Dusty service is information. You can make a
But,
dusty service for purpose
Well,
of.
since there was no order and it was routed through the registry, I thought that this would suffice.
No, you wrongly thought. And the problem of this court is, this court will like to go by law.
I appreciate it.
Show me a provision which recognizes.
And I
dusty
appreciate it.
service.
I appreciate it.
Nothing. The councils also don't point it out. Many courts have done it. I have seen it. According to me, that's not correct. That is not correct. How do we take a stance that they have received notice and failed to appear? Dusty is what? Intimation. You want an interim order, urgent
Well,
interim
in
order.
dusty, when it is.
Contempt cases, Dusty's notices are being issued. It is wrong. I'm not commenting on where, how. Whoever, wherever, it is wrong. Contempt, the notice has to go from the court. How can somebody go and personally give a.
Well, in this
contempt
particular
notice?
case, well,
And
it
the
was.
bar members are totally ignorant about these things. Nobody is pointing it out to the court also.
Lordship correct, 200%. Lordship
This
is
is
200%
Where
correct.
is everybody sleeping? Everybody has forgotten the procedure, the manner in which court proceedings are to be conducted. The councils are happy. Dusty service, go and give it.
No, well, when this.
Someday, if it goes up at the Supreme Court level, there will be huge embarrassment.
Well, in this particular case, dusty was routed through the registry and it is accompanied by a
All
notice.
dusty has to be routed through registry.
It was accompanied by a notice.
But you show me, where is the, show me the dusty procedure in the
And that's
CPC.
correct, Malan. That's
Show
correct,
me.
Lordship. I appreciate it and that's correct.
Tomorrow, if they come and say that, sorry, we didn't receive notice, what does the court do? I was aware, but there was no notice. I have not received any notice. If it is permissible, you show me, we'll accept it. I'm still saying, I'm open to, maybe if there's something I have missed out and it's permissible, then it's fine. But notice has to go by either the High Court rules or under the CPC. Is it not? Otherwise, even an SMS should be okay. Send an SMS to the superintendent of bench section. Why this is not service? The SMS is delivered. WhatsApp message is also service. But tomorrow if he comes and says that I have not received any notice issued by the court.
I have to take a registered steps.
You have to take registered steps means first notice has to be issued.
No, notice was issued on the first day itself, but the instruction was to serve notice dusty and no registered post to mention.
You see the High Court rules. Once notice is issued, steps have to go by registered post within 7 days. Failing that, the petition can be dismissed. Sometimes you read the High Court rules also, we have a rule. In addition to that, sometimes parties are allowed to make dusty service because there is an urgent need to intimate the party. If there is an interim order required, but dusty is not a mode for final disposal of a petition. Whether it is sent by court or. I'm sorry, Mr. Chamu.
Well, it's
You have
my
to-
fault also, Milad. I apologize.
No, we are not on fault finding. But what is correct has to be.
I
done.
should have gone through, Milad, but
Check out the rules, High Court rules.
correct, Lordship is correct. There's no
You
point
know,
of
is
any.
there any mention of dusty being a replacement of registered post to the AD? Either you have to send it through a process server, who has to go and deliver? Or you have to send it by registered post, or after the amendment of Order 5, you have to send it by one of these modes. That's the only mode of service of notice. And in a
Milad,
writ petition.
the
it has
only
to
thing
be-
that I can pray, Milad, as at this juncture, can it be through a process server of the court, Milad? Because it's
No, High Court, we don't engage in process service. Process service. is done in
2020
civil courts.
matters, Milad. This person is due to retire in February. So the only predicament is that,
No,
otherwise.
Process server, there is no scope in the High Court. You have to go by the High Court rules.
Then Milad, register post, no way out.
All right. I have Mr. S. Chairman, I have counsel for the petitioner, also have Mr. R. Learned. Standing Council, you are for which department, Mr. Bhatt?
My lord, this is corporation, my lord.
Understanding
Assam
Council,
State Development Corporation for OBC Limited.
Assam State Development Corporation for OBC. Appearing on behalf of the respond numbers 2
2 to 7.
7, not 7. my
to
lord.
7.
No, my lord, 2 to 2 and 3, my lord. These are
No,
my
he's for 2 and 3.
Advocate here, any government
Right, right.
advocate? Acha, 1, 2 and 3. The respond numbers 3 to 7
No,
are not
4 to
present.
7.
4 to 7, is it? 4 to 7 are not present. Full stop. It appears that although this court had issued notice to the private respondents, no steps by registered post with AD has been taken by the petitioner for service upon respond numbers 4 to 7. Full stop. Although Mr. Chamua has argued that thus the service of notice routed through the registry was made upon the petitioner, yet upon the private respondents, yet he could not refer to any provision in the Guwahati High Court rules or the CPC which permits substitution of service of notice by registered post with dusty service for the purpose of final disposal of a pending proceeding. Under the circumstances, on the request of Mr. Chamua, leave is granted to the petitioner to take steps for service of notice upon the private respondents by registered post
Detail
with
about
AD within a week from today by making the notices returnable in 4 weeks.
May I pray for a date? A date, my lord. I'm not asking much.
You are just asking for things which are completely irrelevant. 4 weeks is not a date. Is it not a date?
After 4 weeks, a date, my lord. At least, my lord, somebody, they may
This
come.
matter again on 2nd of September.
My lord, I'm obliged.
Senior will be in Itanagar. From there, he will go to Kohima, then to Delhi. How can you stop your senior?
My lord, I filed my lord
It's a
additional affidavit.
2012 matter. What is this case, Mr. Paul?
My the case is that, my lord, we are the 17 employees, my lord, daily wages employees under the, my lord, ordinance and the maintenance department of Assam Rifles, my lord. We entered, my lord, get the job for daily wages. And during the last 1996 and in the year 2000, my lord, 12, some of them, my lord, dismissed from the service. Then we have filed, and out of that, we have filed, my lord, petition, pair for more regulation of their service and to reinstate their 3 persons was dismissed from the service. And also, my lord, we paid for my regular wage as provided by the state government of India. So, my lord, the order, my lord, can you see this order, first order passed by this honorable court?
Who is your senior? Huh?
My lord,
When is she coming back?
my lord, it may be fixed on after 3 days because my client has already engaged senior. We filed an Okasnama yesterday. So Mr. Ekip, because 2 weeks time and 13th may be fixed. I have no problem. On 13th of August. In the meantime, if they want to file any reply,
Mr. R.C. Pal and counsel for the writ petitioners submits that the petitioners have engaged an arguing counsel in this case to argue the matter, and therefore this writ petition be listed after 2 weeks so as to enable the senior counsel to address this court. A similar request for adjournment has been made on behalf of the respondents on the ground that the CGC who is holding the brief is currently unavailable. Full stop. Although this matter pertains to the year 2012 and therefore is an old matter, yet since both the sides have prayed for adjournment and having regard to the grounds on which such prayers have been made, this court is left with no option but to defer the hearing of this writ petition by 2 weeks. registry to list this matter again after 2 weeks as a fixed item.
But, I may be paid. I mean, the Eki Purkasi already filed an Okatnama showing his name, man.
A.K. Pugasu is not a senior counsel.
It's not senior, my lord.
Hmm?
His name may be alleged, because I filed in yesterday.
Arvind counsel.
Okalatnama.
Arvind counsel, not senior.
Much
By
of it.
reflecting the name.
I'm not
of
going
the
to say
counsel
senior,
will be
man.
published, yes.
Much.
Item 4.
Yes.
My lord, the matter pertains to non-consideration of promotion to the post of LDA
Hmm.
and the junior assistant like that. First of all, my lord, petitioner was appointed on 21/5/1984. In this regard, my lord, an inter-se seniority list was published.
1 minute, what is the prayer? Where is this 27/11/2015 page number?
My lord, it is page number 54, lordship.
Yes, what is, yes, let us see what is your case.
Yes. First of all, my lord, I was appointed on 21/5/1984.
Hmm.
Thereafter, I have been promoted to the post of unskilled work assistant on 16/11/1991. Although both are the grade 4 post, but my scale is little bit higher than the Khalashi, my lord. And in this regard, my lord,
Hmm.
on 17/2/2011, 6 persons were promoted. Lordship may kindly look into page 27, my lord.
Hmm.
In that promotion list, my lord, 4, 5, and 6, they are junior to me. That's what their date of appointment. If lordship may kindly come to next page, my lord, that is page number 28,
Hmm.
serial number 3, 4, and 5. Their date of joining was 1/6/1984, 24/6/1984, and 27/6/1984. Whereas I was appointed on 21/5/1984. Date of joining. Yes, Khalashi, my lord. Thereafter, my lord, I have made representations to the authority, but nothing happened. Thereafter, lordship may kindly look into annexure 9, my lord, page 33. Thereafter, another 6 persons were appointed, depriving my claim for promotion.
You are appointed as what?
As Khalasi,
And they were appointed as?
Khalasi.
Hmm.
My lord, again 6 persons were promoted to the post of LDA, my lord. My lordship kindly come to page 33, my lord.
So persons junior to you were promoted.
Yes,
You want restoration of your seniority,
yes.
but have you made them parties?
My lord, they are not made as a party, my lord,
Then
but
we cannot consider you.
my lord. Just lordship, my lord.
You
Thereafter,
take
for
the- you take the
non-consideration of
rest
my
of the
promotion,
day,
my lord.
You take the rest of the day arguing your case, but before concluding, tell us how long will you take to implead them as parties? Because you want seniority above private respondents,
Yes.
and you have not impleaded them, so obviously the court will not pass any order today. These are very fundamental principles
Yes,
of
it is
law.
there, my lord.
How come the learned members of the bar have no idea? If the court points out, somebody gets agitated, somebody gets emotional.
The thing is that, my lord, subsequently the persons, 6 persons,
Hmm.
they were reverted again, my lord, to their original post.
Hmm.
After filing of the writ petition, secretary, my lord, they have reverted them again to their original post.
Are you claiming seniority above anyone today?
Actually, my lord, what happened? Actually, the first 6 persons who, 3 persons who were promoted in the year,
Are you claiming seniority above anybody today? Yes or no?
my lord, actually, what happened? I am actually challenging. Yes, my lord, it is
Then
definitely.
we'll not give you that relief unless you implead them as parties.
Then, my lord,
Whatever
I'm-
is actually, eventually, it doesn't matter.
then
You
1
are-
week
you are
time. will-
claiming seniority above other department candidates. You have not impleaded them as party. What kind of a writ petition is this?
Then, my lord, 1 week time will begin.
Why you file your application for
Yes.
impleadment. Mr. So-and-so, learned counsel for the Mr. R. Bhattakur, learned counsel appearing for the departmental authority. In this writ petition, the petitioner is primarily seeking restoration of her seniority over some other departmental candidates who have not been impleaded as parties in this writ petition. In the absence of such departmental candidates, the prayer of the petitioner cannot be considered by this court. As such, on the request of Mr. Chaudhary, 2 weeks' time is granted to the petitioner to file appropriate application for impleadment of private respondents in this writ petition. Register to list the matter after the IA is filed.
Deeply. Okay.
Item 6.
May it please your lordship. My lord, matter relates to recovery of money from pension, my lord. Petitioner's pension. My
Rafiq
lord, that-
Masih. Is it covered under Rafiq Masih?
Lordship, lordship,
That is the judgment from Punjab, is it?
lordship, state of Punjab versus, I was about to rely upon that question.
I have the tips in logic because in that case, Honorable Supreme Court had stated that if at the time of taking those money, if someone had given an undertaking that excess amount will be deducted, authorities, that in that case, that will be applicable.
My lord, that is at the time, in 2005, my client retired. The petitioner before your lordship retired in the year
Let us hear the
2005.
facts. from him.
Lordship.
Yes, Mr. Ram.
Lordship, the petitioner from the Sasastra Sima Ball, he retired as a head constable in the year 2005, my lord. On 31/7/2005, he retired.
Yes.
And thereafter, my lord, because of the revision of pay, my lord, brought into effect by the central government, my lord, time to time, his pension was also revised, my lord. Finally, on 2000,
So he retired from service on 31/7/2005 as a,
as a head constable, my lord, upon attaining the age of superannuation, my lord.
Hmm. That is which grade? Grade 3 post.
Great trip.
Then what happened?
My lord, in, from time to time thereafter, his pension also got revised because of the revision of pay. From 2014 onwards, my lord, he saw that his pension, there is some deduction of some amount from his pension, my lord. He immediately submitted representations, and there followed a letter, my lord, from the only one letter communication which he receives
Hmm.
is Lordship Annexer M, page 35, my lord.
Hmm.
Madam, this says kindly refer to your letter dated, because you are submitting representations. Information regarding revised basic pension grade pay and ACP is as under. You have superannuated on 31/7/2005 from government service in the pay scale of rupees 3,280 so and so, with last pay of rupees 7,733, which includes dearness pay at the time. Accordingly, your pension was finalized on 3/8/67, including DP. As per recommendation 6 CPC, your revised basic pension should be so and so with grade pay of 2,000 rupees, copy of the ready reckoner revision pensions is enclosed here. Needful. Earlier is wrongly fixed as 11,651. This is the only cost they have shown, my lord.
No, but is there any recovery?
Proceed.
Is there any recovery from your client?
Lordship, yes.
Oh, when-
Recovery from 2014 onwards, my lord. 1,900 rupees was recovered from this pension amount, my lord.
Hmm.
So he, after submitting representations, we prefer this repetition.
No, just a minute. According to them, what is the correct pension amount?
My lord, as per the last communication, the pension amount should be 5,828, my lord.
And how
With-
much is this client, your client getting?
Lordship,
How much your client was actually drawing as pension?
my lord, at one point of time, he was drawing 11,651. It's a fact, my lord. We have also stated in the repetition. Subsequently, when in the next revision, when the department realized that it should be 5,000 something, he was drawing 5,000. And from that 5,000 amount, my lord, this recovery was made, my lord.
So therefore, his pension according to the department should be 5,828.
5,828.
That you don't have any problem.
No, my lord.
But how much were they paying your client actually? 5,828.
My lord, 5,828 minus, my lord, 1,900 rupees.
1,900 is what? What is
Exactly, my lord. We submitted.
Where is the order of 1,900?
No, there's no order, my lord. No order has been passed. Even they have also not produced any order to that effect, my lord. Where they are only plea in the affidavit in opposition that this may be a recovery done by the bank, which is, my lord, unbelievable. Because bank, in absence of the amounts, are directly credited to the account of the pay, my lord, drawer. My lord, they are only plea in paragraph 9, my lord.
So apart from this, there is no other order.
No other order.
Huh?
No other order. That is why we came before your this honorable court, and on 4/8/2017, an interim protection was granted, my lord. If your lordship peruses the order dated 4/8/2017, my lord.
And how much they were recovering?
1,900 rupees, my lord.
So, Miss, you issue an order to him. How can you unilaterally recover? How much money you want to recover for which period? At what?
Yes, Lordship, in my affidavit, we have stated Lordship, Lordship may
No, no, no,
kindly.
where is the order? Where is the order? You have to tell him that you have drawn this much of excess. We are going to recover this and we'll do it in this mode. Where is the intimation of that? Without anything, how can you suddenly start recovering? We'll allow the repetition. Another 3 minutes to make your argument.
Lordship, in that case, Lordship may call for the records, Lordship, because
Nothing.
in my affidavit, we have stated
No,
that,
no,
Lordship.
You issue that order to him.
Uh,
You have to pass an order that
Lordship.
this is our decision. You have access drawn this amount or this much money from such and such date, which the department is liable to recover from you. So we will be recovering this much amount, and this is how we are going to do it. And therefore, we have started recovery of such amount every month. Where is that order? There is nothing mentioned anywhere. Affidavit, you cannot take this stand.
This provision is in the office memorandum that if excess, although order,
All right, add Mr. R. Gautam.
Lordship, at present, he is, that is from 2000, earlier, Lordship, at present.
Are you
he-
not understanding or pretending not to
No,
understand?
Lordship.
You have to pass an order.
Lordship,
Yes. You may have the power, but you have to pass the order. That's all. You pass the order. Till then, we'll make the order absolute, but once the order comes, then it will take its own course. He may challenge it, then we'll see whether Rafiq Masih comes in or Jagdev or Baldev comes in. Now we cannot go into all these things. Now you first tell. Nobody knows. How long will you recover? How long? How much
Lordship.
money you will recover?
period I have stated, Lordship, from 1/1/2016 to 9/5/2014. That period.
1/1/2016.
Then,
Six,
then,
2006.
then there will, question of limitations will come. Where is the demand? You have started immediately recovering. You have to put in a order, and then only we'll see whether it is permissible, whether there is, it's hit by law of limitation or Rafiq Masih. If not, then you continue. If yes, you cannot. But those things cannot be decided today. Because on the basis of your affidavit, it cannot be decided. Where is your affidavit?
Filed on
Third
5/6/2018.
page, starts from page 30,
40.
40. Page 41, that facts I have stated and also reply. Paragraph B, Lordship, B onwards.
And which clause of this 2013 OM you want to rely upon? Which clause?
Lordship, this is the revision of pension regarding the pensioner prior to 2006, Lordship. This clause 2, page 46. This revised pension was done as per this lordship. And there we found that it was wrongly, higher pension was credited in his account.
Take down. Heard Mr. G. Rahul, learned counsel appearing for the writ petitioner, also heard Ms. B. Sharma, learned CGC appearing for the respondents. Full stop. The facts of this case in a nutshell are that number 6652533 ex head constable bracket general duty Sri Chandinath Borua, that is the writ petitioner hearing, was initially appointed under the Sasastra Sima Bal bracket SSB bracket close on 2/5/1966, whereafter he had joined service. Full stop. During the course of his service, the petitioner was promoted to the post of heads constable bracket general duty bracket close with effect from 01/07/1974. Full stop. Eventually, the petitioner retired from service with on attaining the age of superannuation with effect from 31/7/2005. Full stop. The petitioner was entitled to receive pension. Therefore, the authorities on processing his pension papers had sanctioned pension to the petitioner, which he went on drawing with effect from the date of his retirement. Full stop. After the recommendation of 6th CPC, after the implementation of the 6th CPC recommendation, the pension of the petitioner was revised and he was allowed to draw an amount of rupees 11,651 per month with effect from 1/1/2006. Full stop. However, subsequently, the respondent had detected that the pension paid to the petitioner was in excess of his entitlement under the rules. Situated thus, the commandant, no, the senior accounts officer of SSB, Ministry of Home Affairs, Zonal Pay and Accounts Office had issued a communication dated 23/2016 addressed to the petitioner, intimating him that after the implementation of the recommendation of 6th CPC, his basic pension would be 5,282 per month, rupees 5,282 per month, and not rupees 11,651 per month. Full stop. Thereafter, per month, full stop. Next paragraph, Mr. Rahul, learned counsel for the petitioner, submits that the respondents had not only unilaterally reduced the pension of the petitioner from rupees 11,651 to 5,828, but went on to deduct a sum of rupees 1,900 from the aforesaid amount of rupees 5,828 without issuing any formal order to that effect, thus prejudicially affecting the rights and interest of the petitioner. First of all, according to the learned counsel for the petitioner, such recovery of pension from the petitioner without issuing a formal order of recovery would not only be illegal, but the same would also be in violation of the law laid down by the Supreme Court in the case of State of Punjab versus Rafiq Masih. Give the citation.
2015 4 SCC 334. 15 4 SCC 334.
Responding to the above arguments, Ms. Sharma submits that if the pension of an employee is wrongly fixed, it would be permissible for the departmental authorities to correct any computational error. Full stop. A computational error. Full stop. She submits that in the present case, having realized the mistake committed by the department, corrective measures were adopted, which had resulted into reduction of pension of the petitioner. According to Ms. Sharma, further submits that such a recourse is permissible under clause 2 of the office memorandum dated 28 January 2013, bearing number capital F full stop N capital small O NO full stop 38/37/08 dash P and symbolical N PNPW bracket A. You see in annexure annexure R1 of the counter affidavit. It's flag marked, yellow flag marked. Issued by the Government of India, Ministry of Personnel, PG and Pensions. Therefore, submits Ms. Sharma. No fault can be found with the action initiated by the department in this regard. In support of her above submission, Ms. B. Sharma has also placed reliance on the decision of the Supreme Court rendered in the case of
High Court of Punjab and Haryana and others versus Jagdeep Singh.
High Court of Punjab and Haryana. Give the citation versus Jagdeep Singh reported in so and so, so and so. Is it a reported judgment?
Yes.
Stop. After going through the materials on record, I find that taking note of the grievance expressed by the writ petitioner, the learned single judge had passed the following order on 4/8/2017. You quote it, 4/8/2017, the order is there, we quote it. Pursuant to the order dated 4/8/2017, further recovery from the pension of the petitioner has not been done till today. Full stop. Mr. Rahul Gautam and counsel for the petitioner has fairly considered that he is not questioning the refixation of the pension of the petitioner at the rate of 5,828 rupees 5,828 per month. But the grievance of the petitioner is the manner in which recovery is being sought to be made from a retired employee without passing any formal order of recovery by citing proper reasons as well as facts and figures. After careful examination of the materials on record, I also find that there is no formal order issued by any competent authority indicating as to what is the amount of excess drawal by the petitioner, the period to which the same corresponds, and the manner and mode in which such amount is sought to be recovered by the departmental authorities. First, what the respondents have done have merely started making recovery from the bank account of the petitioner by issuing instructions to the bank. First, the petitioner being a retired employee who was drawing certain amount of pension is undoubtedly entitled to a formal order of recovery of pension so as to enable him to examine as to whether the same is in accordance with the law or the matter can be agitated before the court. Since no such formal order has admittedly been issued to the petitioner, said aspect of the matter cannot be gone into in the present proceeding. Therefore, this writ petition is being disposed of by providing that the respondent authorities would be at liberty issue a formal order to the petitioner indicating the amount of excess drawal, the period, period to which the same correspondence and the procedure sought to be adopted for recovery of the same. Upon issuance of the formal order, it will be open for the departmental authorities to take appropriate steps in the matter as may be permissible under the law. Till such time, the formal order is communicated to the petitioner. Operation, the interim order dated 4/8/2017 passed by this court shall continue to operate. With the above observation, the writ petition stands before you.
What the lordship is mentioned subsequently under 7th Central Pay Commission, it was revised and at present he is drawing much more than what. was.
You give him the order, that's it. You have to inform him. That is why these problems are happening. No intimation is given. Suddenly, we have made a mistake. Oh, if it is barred by limitation, then even if it is a mistake, you cannot recover. Bank money can be swallowed if it is barred by limitation. You recover it from the person who is responsible. Yes.
Matter relates to the Department of Handloom and Textile and relating to the monetary relief if the employee is redesignated to another post. So I was as master weaver at the Handloom and Textile Department. Thereafter, in the year 2013, I have been redesignated as information officer. So that notification is there, my lord. So the whole case revolves around the word redesignation. That annexure to page 12, order of 2013. So my salary has been fixed at the scale of pay rupees 5,200 to 20,200 with GP grade pay 3,300. And there are instances where other department, they are getting the same pay scale, but grade pay is 5,400. That is the difference, my lord, core difference. So I have claimed the department has also asserted that thing, but subsequently I was not given that benefit. So that order is at page 12, my lord. Thereafter, page 13. Now, why my salary should be the pay, grade pay should be increased, that justification is there, given by the Handloom and Textile officer in charge, page 13. Because my workload is differ from the other employees.
Yes, where is your initial appointment order?
My lord, that I have not enclosed, but gradation list is there, annexure 1, page 11, my lord. I am the senior most master weaver. So that is not disputed, but that subsequent term redesignation. So as per annexure 1, page 11, I am the senior most. I have the qualification, no other persons had that qualification. So I, along with another person, were redesignated from the post of master weavers to the post of one is of information officer. I was redesignated as information officer HRDC under the Handloom and Textile Department.
So it is pay scale is 5,200 to 20,200
Yes,
with grade pay of 3,300.
yes.
Then what has happened? They are not giving you the grade pay.
No, my lord. That is, they are giving.
Hmm.
Actually, that grade pay is same with the earlier post, master weaver. So what my claim is that I should be given the pay scale is same, but grade pay is of 5,400. 4,700, sorry. And that justification that why my grade pay should be increased, that is at page 13, my lord.
Page 13.
Yes. It is issued by Officer in Charge, Handloom Research and Designing Center, that is HRDC. So my new workload is this.
Huh?
My new workload is this from my previous works. So my,
Your post is research assistant textile testing.
no, my lord. Second part. Sri Apurva Boisya and Sri Jagat Boisya presently holding the above post Master Weaver in HRDC is hereby redesignated as Research Assistant and Information Officer. My post is Information Officer. That other person, Apurva
This is
Boisya,
a
is,
cadre post. This is a cadre post.
yes,
This is a cadre post.
and yes, and it is already,
Listen.
my lord,
Don't rush. You rush, you will crash.
is correct.
Is it a cadre post?
As per my information, yes.
We are not concerned what information you have. We are asking you, is it a cadre post? If you know, give an answer. If you don't, take time and find out.
That exact
Information, we are not
concerned.
concerned. You may have all kinds of information.
Uh,
Is it a cadre post? If it is, show me that rule.
that I have to check, my lord, exactly.
You don't know the fundamentals. He will get the pay of whatever pay is assigned to the post under the rules. If it is 3,300, that is the order the court will pass. If it is 5,300, that is the order the court will pass. Who says what, which deputy secretary writes to whom, we are not concerned. Pay is governed by the rules. What does the rule say?
I have to check this part, but what I have seen, I have annexed also.
Which are the rules? Which rule governs which rules creates the cadre of research assistant and information officer of HRDC? Do you know the name of the rule?
ROP 2010, I
ROP 2010. Oh, Mr. So-and-so, your name
have to
please?
check, my lord.
Huh?
DK Nath.
Mr. Tikanath, like counsel for the petitioner, prays for and is granted 2 weeks time to prepare the matter, further prepare the matter
Right.
and argue before the court. Mr. So-and-so is present on behalf of the respondent. For this matter, you have to have elementary knowledge.
Actually, Mr.
People are trying all kinds of things and then they are unhappy with the judge. Service matter goes like
Certainly
mathematical.
not, my lord.
We have seen things. Fundamental knowledge idea is not there and people are arguing all kinds of things. You
I will
are asking for pay fixation, you have to show it from the rules. Nothing else and nothing more.
That is correct.
If you can't show it, you don't get any order.
I will,
Yes, next matter.
my lord.
822.
My lord, 8 and 9 are same. If your lordship should kindly take item number 9, not to the motion.
Yes.
My lord, a very short point is involved in this case.
Hmm.
Now, the petitioners, they are presently working as, my lord, assistant audit officer under Director Audit Local Fund in the Assam. Now, Public Service Commission, my lord, issued an advertisement on 3/5/2018 inviting applications for filling up 32 number of posts of audit officers. Now, the controversy arises from filling up these 32 posts. Now, the advertisement was for 32 posts. Midway, my lord, after the selection process was started, an intimation was given by the requisitioning department, administrative department to the Public Service Commission, and it was raised to 57. Now, our submission is you have to confine the recruitment process to the advertised post, nothing beyond that. Now, initially, there was an interim order passed in this proceeding. Then, my lord, the persons were selected beyond Because interim order was, don't fill up the post beyond 32. So those whose names appeared from 33 onwards, they file an interim application before the learned single judge, where they pray that since it is a promotion exercise, it is not direct recruitment, those principles laid down in Prem Singh, Madan Lal will not apply. That was the case. So there was slight modification of the order by the division bench, my lord. Eventually, division bench remanded the matter back to the Honorable Court for consideration. Meanwhile, my lord, there is a judgment of the Supreme Court where precisely on the same point, Supreme Court has said even in promotional exercise, the advertised post alone can be filled up. So that is the point. Now, please come to the writ petition.
Why two repetitions?
By different persons, my lord.
And who is for the other? You are appearing for both of them. You are appearing.
Yes,
in
yes,
both
yes, yes. In one petition I appear, one petition my learned friend appear.
Page 30 is the advertisement.
Yes,
Third
my lord,
net,
please
third
come
net.
to page 31. Now, page 30, my lord, what is relevant to note is the serial number 8, the subpara. The filled in application accompanied with necessary documents must reach the office of the APSC honor before 4/6/2018. So 4/6/2018, if any vacancy has arisen after this cannot be a subject matter of this selection. Then please come to page 31. Now, the grand total is 32 vacancies. Now, my lord will kindly come to page number 38. Kindly note the date, my lord, 18th of February 2019. That is beyond that last date. With reference to the above, I have the honor to state that Assam Public Service Commission had conducted a written examination for filling up of 32 number of post of audit officers on promotion from assistant audit officer who had at least 3 years of qualifying service. There were 80 such qualified assistant audit officer who had appeared in the aforesaid examination. It may be mentioned here that at the time of advertising the post of audit officer, there was a vacancy of 32. Currently, vacancy has risen to 51. Though originally it was proposed to fill up 32 number of posts of audit officer, it is now required to fill up all the existing vacancies, considering the requirement of the director. So admittedly, the vacancies has arisen, my lord, after the last date, and admittedly on 18th of February only, 2019, the administrative department wrote to the Public Service Commission. Then on, my lord, page 39, Public Service Commission came up with a select list at page 39.
So your clients did not apply.
No, our clients appeared and our candidates, my lord, could not qualify in the examination. There is an aspect also that I'll come, my lord. Now, we got certain exemption marks, meaning thereby the papers which we have cleared, next time when we sit in the departmental exam, we need not appear in those. That way also my right has been prejudiced. Our right has been prejudiced. Now, at page 40, lordships will find 57 recommended. Then, my lord, we approached this honorable court. There was an interim order that beyond 32, you do not appoint. So 32 are appointed, we have no grievance.
Interim order is in which case?
Yes, in both the cases it is here, my lord. Binoy Kumar Kulta.
What is the date of the interim?
1 second, my lord.
19/12/2019.
Huh.
19/12/2019.
My lord, may kindly have a look at the other matter, my lord. Binoy Kumar. Last paragraph, my lord. The respondents are allowed to fill up only 32 number of posts of audit officers in the Assam Local Fund Audit Service as advertised on 3/5/2018 and as provided in clause 12 of the said advertisement.
So even the 32 will be subject to outcome of the writ petition.
No, that was not required actually.
Anyway,
That was not required, yes. We do not have any grievance against that, Miller. Now please come to page 41 of the writ petition.
which writ petition?
The earlier one, my lord, the one I was referring.
Yes.
With reference to your letter cited above, I am to say that 80 number of candidates appeared in the above mentioned examination, which was held by the commission on so and so date, a recommendation of which has already been sent by letter dated 7th of November 2019. Now I am sending the name of 14 candidates mentioned below who secure exemption marks in one or more subjects in the Assam Local Fund Audit Service Promotion Examination 2018. Now, these are the petitioners, my lord, who got exemption marks. The effect of securing exemption mark is the papers which we have cleared, we need not clear next time. So when, my lord, beyond 32 number of vacancies will be advertised or will be filled up, we'll have to sit in the departmental exam. In that exam, we did not appear again in those papers which we have already cleared. That is what is meant by securing exemption mark. So that way also we are prejudiced. Tomorrow when there will be a fresh selection, we'll have to appear in all the papers. Otherwise, if it is disregarded. Now, my lord, this is the case. Question is whether you can fill up more than the advertised vacancies. Now, the issue we cropped up before the Honorable Supreme Court in a recent judgment, my lord. This is reported in 2021 for SCC 494. Kindly come for the facts, my lord. First para. Government of Maharashtra issued a requisition on 2/6/16 to the Maharashtra Public Service Commission to conduct limited departmental competitive examination. Similar examination is here for selection of candidate to the post of police sub-inspector. The Home Department, Government of Maharashtra, via Government Circular dated 27/6/16, notified 828 vacancies, out of which 642 were for open category and 186 were from various reserve categories for promotion to the post of sub-inspector through limited departmental competitive examination 2016. The selection was governed by the provisions of the so-and-so rules. Then my lord will kindly come to para 14. Para 14 at 499. The impugned GR 6 to fill up double the number of vacancies which were notified for LDC 2016 by circular dated 27/6/16. It is well settled in service jurisprudence that authority cannot fill up more than the notified number of vacancies advertised, as recruitment of candidates in excess of notified vacancies would be violative of Article 14 and 16(1) of the Constitution of India. The tribunal has vacated the order of status quo dated 18/10/19 on the ground that the two applicants had participated in the examination but failed to qualify. This could not be a justifiable ground to vacate the interim order, since the promotional prospects of the petitioners would be seriously prejudiced, since a block of 636 additional candidates would be appointed as police sub-inspectors over and above the applicants. Then my lord will kindly come to para 18. We find that the High Court in the present writ petition had issued a direction to the state to send the additional list of 636 candidates for training of 9 months during the pendency of the proceedings before the tribunal. We are of the view that such a direction ought not to have been passed in the writ petition filed by the present petitioner, were agreed by the impugned government resolution dated 22/4/19, which is the subject matter of challenge. In view of the discussion herein above, we allow the present civil appeal and direct that government resolution dated 22/4/19 will remain stayed during the pendency of the proceedings before the Maharashtra Administrative Tribunal. We set aside the order dated 30/11/19 passed by the Maharashtra Administrative Tribunal, which vacated the interim order dated 18/10/29 and order dated 6/3/20 passed by the Bombay High Court in so and so. We direct the Maharashtra Administrative Tribunal, Nagpur, to decide the pending in a period of 6 months from the date of receipt of this order. The tribunal will ensure that additional 636 candidates are given notice of the pending order to the state to enable them to appear and participate in the proceeding. Tribunal is further directed to club all pending original application, etc., etc., etc. Now, there was initially an order which was vacated. So, my lord, therefore, the principle that the selection process, be it for direct recruitment or promotion, it should be confined to the notified vacancies, that has been followed in promotion also. In fact, this was the argument which was advanced before the learned single judge while seeking to modify the order as well as before the division bench. So therefore, my humble submission is, my lord, 32 posts they have filled up is well and good. The rest of the vacancies should now be again advertised and whosoever eligible should apply. And since we have got exemption marks, we'll have to appear but not in the papers which we have cleared. That is our case, my lord. So the writ petition should be allowed to the extent that the authority cannot fill up more than the advertised notified vacancies. That is my case, my lord. And my lord, yes, the rule is also very clear. I'm sorry, I should have placed it. Rules complete set up. My lord will kindly come to rule 17(3). I think at page number 118.
119.
118. Rule 17.
119.
The heading is Part 3, Audit Officers, page 118 of the Gazette.
Yes.
Promotion through departmental examination. Promotion shall be subject to the following reservation. 75% of the recruitment in a year of recruitment in the cadre of audit officer shall be filled up by promotion of assistant audit officer who qualify in departmental examination called Assam Local Fund Audit Service Promotion Examination. Then 2. As an assistant audit officer to be eligible for appearing in the said examination shall have to complete at least 3 years of service as assistant audit officer on the first of the year of the recruitment. 3. The Assam Local Fund Audit Service Promotion Examination shall be conducted by the Commission in accordance with the rules and syllabus as in Schedule 3 and shall be held at such interval as the appointing authority may, in consultation with the Commission from time to time, determine. A list of candidates who have qualified in the said examination shall be prepared by the commission in order of merit and forwarded to the appointing authority. Now, this line is very important. Promotion shall be made from the list subject to availability of vacancy. So availability of vacancy means, my lord, that is the number of vacancies which will be advertised and which will be considered for promotion. That means on the date of the advertisement. Now, my lord, will kindly come to Rule 20 for a moment. At page 120. Subject to the provisions of the sub-rule 2, appointment to the cadre of audit officer shall be made in accordance with the order determined by the commission in the list referred to in sub-rule 3 of Rule 17 and sub-rule 2 of Rule 18. Now, 2 is not, but 3 is important. At next page as 121. The list of departmental candidates for promotion to the cadre of audit officer under sub-rule 3 of Rule 17 shall remain valid for 12 months from the date of approval of the commission. So when we read, my lord, Rule 17 and 20 harmoniously, what follows is what can be, advertised or what can be notified is the available vacancy. So
So
therefore,
these excess vacancies were anticipated or actual vacancies?
no, my lord, those are future vacancies. Those are not anticipated.
Future vacancies.
Yes, my lord, what is permissible to fill up is an actual vacancy and anticipated vacancy. But a future vacancy cannot be filled up by an, my lord, process which is initiated. The bar is always against, because this is future. Because the last date was, my lord, date to given us
4/6.
4/6/2018. Whereas the letter of the department was on 18th of February 2019. So these are future vacancies. And my lord, the other aspect that we got exemption marks in some of the papers, that is an advantage. Now, if a new selection process is to start afresh, then my lord, I'll lose that benefit also. In any case, my lord, if the selection process or recruitment process is confined to the notified vacancies, nobody stands to lose anything, my lord. There's no question of any bias or prejudice. The vacancies which has arisen post, that should be advertised again and should be filled up. Yes, an argument could lie that in a departmental promotion, why there should be an advertisement. But there was an advertisement. There was an advertisement. So that being the position, my humble submission is, my lord. It's a fit case where lordships will.
Some certain time things done by the department.
That creates cause of action.
Oh. Who is for the department?
I am for the APSC, my lord. I have no mass.
Department has run away. What will this?
My lord, I find exactly.
What is the point in issuing an advertisement?
Yes, my lord. Advertisement, my lord, they are probably that point of there is a vacancy. That's why they wrote to us. But we have to go by our rules, because your lordship kindly see earlier, my lord, if it is post is 30, then double of the my lord will be selected. After FRBM, my lord, exact vacancy has to be notified. But here is the rule, my lord. Those who are qualified, getting qualified mark, we have to forward it. That is up to you. Our duty is to, my lord, I have clearly mentioned in para 10 of my affidavit that our duty is to, as per a rule, those who are getting 40% marks, those who are qualified, we prepare a list and send it to them. 45. So that was the, so you cannot confine at least the exact number of vacancies, my lord.
Where is the counsel for the department?
My lord, before my learned friend makes his argument, there's one aspect I think I must have brought up to lordship's notice. If a lordship kindly takes the rule for a moment, why this advertisement aspect is important.
Yes.
Now, 75% would be filled up by limited departmental exam. And please come to Rule 18. Rule 18(1). A competitive examination called Assam Local Fund Audit Service Recruitment Examination in accordance with the rules and syllabus as in Schedule 3 shall be held by the commission for filling up 25% of the vacancies in a year, in a year in the cadre of audit officer at such interval as appointing authority may, in consultation with the commission from time to time, determine. So that means in the cadre of audit officer, 25% is by direct recruitment and 25%, 75% is by promotion, that too by LDCE. So possibly, my lord, to work out, to figure out the figures and all this process is being followed. Not that, my lord, any arbitrariness is exemplified by resorting to an advertisement. This, it shows rather transparency, my lord.
No, this advertisement was published in a newspaper.
Yes. Newspaper, Niki. Website and newspaper, my lord. And it is published by the public service, so therefore it has to be in some public fora. Not by the department, it is by APSC.
No, but requisition by the department.
Requisition by the department.
Yeah, Mr. Shalia. Going for a, who is appearing?
Lordship, I have filed my affidavit. Lordship, basically, these are not direct recruitment. These are promotional examination and vacancies arises in the meantime, Lordship. We generally give them opportunity to come and join, Lordship. That was the situation. In this case, Lordship, that advertisement for 32 posts was only an information. It was not for any other purposes, Lordship. It is a departmental. Lordship, I kindly see my affidavit, Lordship. I want Fulbor Ali, Muhammad Fulbor Ali, Lordship. He is response number 2, 1 and 2. 8.
Who is the deponent of your affidavit?
Fulbor Ali, Lordship. Muhammad Fulbor Ali. Starting from page 43, I think. Is now
Which rate petition you are referring to?
9305/2019.
All right, affidavit has been filed only in one of the petitions.
Yes, Lordship.
It is. Yes, page 43. Yes.
Page 45, Lordship, paragraph 10. Paragraph 10.
Yes.
It is, however, submitted that since it is a promotional examination, apart from the candidates from the audit service, no private candidate had appeared in the examination. Only those candidates who have completed 5 years of service as assistant audit officer had appeared in the examination. As such, contention of the petitioner is not correct. Next, I am coming to paragraph 12, Lordship. The answering deponent begs to state that this is no direct recruitment but promotion of the in-service candidates. Those who have completed 5 years of the service can sit for examination. As per rule, advertisement is not a precondition for selection of candidates for this promotional examination. Neither relevant rules require to declare the number of vacancies. The advertisement was made only for information about the selection process, and the department may also issue office memorandum in lieu of advertisement initially for information of the candidates without mentioning the number of vacancies. The existing vacancies got increased in the passage of time, and government servant get promoted and get retired. As this is a qualifying examination for giving promotion to the departmental candidates, that is assistant audit officers, It is in the interest of the department that more the candidates qualify, more will be absorbed to the vacant positions.
Mr. Nayak, just a minute. Forget what is there in the advertisement, no advertisement, forget it. Let us take it that this is an internal departmental exercise. The rules have to have a cutoff date. That vacancies arising within this. Let's take it that it's a simple exercise of promotion. Even then, you can't do it in a completely unruly manner. So when you started the process, let's take it that the process was started with the publication of the notice.
Lordship.
So the vacancies before the publication of the notice can only be considered. Is it not?
Lordship.
Because the rules must be speaking something about it. That which vacancies arising in which year can be filled up in which year. You cannot suddenly bring in vacancies 10 years back or next year vacancy. These you can't do. So why did you mention about 32 vacancies on the date of?
At that point of time, 32 vacancies were there.
Then you
But
come
generally,
to-
what happens, Lordship, candidates who are eligible, Lordship, they participate in the examination and APSC publish the result. In that result, Lordship, in this result, number of 37 or 57, 57 persons qualified, Lordship.
That may be because they have to make it almost double the number. No, we are not concerned about how many qualified, how many not. The vacancies which were considered while initiating the process,
Lordship.
fill it up. And the next vacancy, more candidate will be eligible.
No, 32 has already
We are
been,
not concerned about the petitioners.
Lordship.
We will also look about the people who have not been a part of this because they were not eligible. Fundamentally, the law is simple. You cannot rope in subsequent vacancies.
No.
Because that was-
57 candidates found eligible. There is a specific cutoff mark, Lordship. If somebody scores more than that,
cannot fill up more than 32 vacancies.
no, so far as 32 is concerned, those 32 will be filled up by the first 32 candidates. For the subsequent vacancies, Lordship, the subsequent candidates will be given promotion.
You complete your argument, Mr. Nayak.
Then Lordship may kindly come to paragraph 13, Lordship. Rule corner here to Silva. Paragraph 13, Lordship,
Yes.
page 46. The answering deponent begs to state that this is a selection examination only, and as such, any departmental candidate who is otherwise qualified to take the examination can sit in the examination. There is no age bar. If they do not qualify in the examination, they can sit in the next examination. APSC is a constitutional body, and as per concerned service rules, holding the examination are entrusted to APSC. But this is my affidavit, Lordship, basically. Now, so far as rule is concerned, Lordship, assistant audit officer. 13, no, 16. Photo to rule nice again. 13 to section, rule page 15 to rule আপনার হেৰি করব 23 নহয় ভ্যালিডিটি to চাই আছো 12 months. সেইটোৱে কৰি থকা হ'ল।
Mr. Nayak, please come to rule 15. That's what I was asking.
Lordship.
Please read rule 15.
15 to 22. Yes, Lordship. General procedure for promotion.
Hmm.
Before the end of each year, the appointing authority shall make an assessment of the likely number of vacancies to be filled up by promotion in the next year.
Hmm.
Next page to sir. Next page to. Yep, dekhana bhai.
Then what is the next provision?
An assistant audit officer to be eligible for appearing in the said examination shall have to complete at least 3 years of service.
15.2.
Yes, Lord.
Appointing authority, rest is not legible here.
Lords.
Do you have a copy of the?
15.2.
The appointing authority shall then furnish to the board the following documents and information with regard to eligible officers equal to the number of vacancies in order of seniority. That means having regard to the number, the matching informations will be forwarded to the commission.
So where is it mentioned about holding of departmental examination for the?
That is rule 17. Rule 17.
3.
1.
Yes, 1.
Promotion through departmental examination. 75% of vacancies in a year of recruitment in the cadre of audit officer shall be filled up by promotion of assistant audit officer who qualify in the departmental examination called so and so examination.
Initially, vacancy to not create probability will be to mention that. $17.1 Lords.
Yes.
75% of vacancies in year of recruitment in the cadre of audit officer shall be filled up by promotion of assistant audit officer who qualify in departmental examination called the Assam Local Fund Audit Service promotion examination.
Right. Now, as per rule 15, the vacancies are available at the end of year 2017. Those can only be dealt with in the process of departmental examination. Is that correct?
No, for appearing in the departmental examination, that 3-year qualification is sufficient.
No, no.
If you are Lordship. Vacancy pass is
What
different,
was
Lord.
the number of vacancies at the end of 2017? Audit officers. You can only fill up those vacancies.
These are all 2017 vacancies, Lordship.
Which are?
57. That data I can produce, Lordship.
Then why have you released only 32?
It is not, no, initially that the information was only about 32. But that is why this statement, Lordship, that 32 statement is not a necessary as per rule, Lordship. It is only an information,
No, you may be right.
Lordship.
We are not on that, but the rules you have to follow. So these 57 vacancies arose when? Did you make any statement on
No,
affidavit?
so far as it is not mentioned here, Lordship, but to my knowledge, Lordship, all the vacancies were pertaining to 2017.
Let them file an affidavit. Mr.
Lordship,
Chaudhary, that according to me would have a very relevant.
Of course, my lord. If it is a 17 vacancy, I have no case. I'll not argue for the sake of arguing. It's very clear.
Let
But
them-
my lord, that statement should have been there in the affidavit. Today, this submission is made.
This is the Commissioner and Secretary of Finance Department will swear the affidavit.
Lordship, I will place that instruction, Lord.
No, affidavit, not instruction.
Instruction regarding year of arising the vacancies, Lordship. To my information, these are 17 vacancies. I will place that on record, Lordship.
No, but unless there is an affidavit, the court cannot
Lordship,
act
I will
on
place
that.
one. Final
Yes, it will come on case.
affidavit.
May it please, your lordship, sorry to interrupt your lordship, I'm appearing for the private respondent. Some more information needs to forthcome. First of all, your lordship, the petitioners have apparently failed in the examinations. And they're making their submissions, which is not in the pleadings. 18 to 2019 is the crux of the issue. Now, as per my instructions, which I can demonstrate from the merit list, those candidates who get exemptions, say I am appearing in, we are supposed to appear in 8 papers. We have passed in 2 papers, not passed. I need to get 50 marks. So I need not appear in those 2 papers. And the rest 6 of the papers I have to appear. Now, even if I qualify next time, I secure the pass mark, my names will be at the bottom of the merit list. So on that, in that view of the, yes, your lordship, that is relevant. Why I'm saying so? Why I'm saying so, your lordship? Your lordship will kindly give me one more minute here.
We are going to adjourn it for filing affidavit.
But that issue
Let me
has,
dictate the order, then you argue.
your lordship, that issue has to be addressed by the
It's
APSC.
amazing, councils don't even understand the mood of the court sometimes. We have already said the government has to file an affidavit.
APSC also has to file an affidavit to that extent, your
No.
lordship.
No. APSC doesn't have to. I've already filed. APSC has already filed. Heard Mr. K. Chaudhary, Learned Senior Counsel, assisted by Learned Counsel appearing in these writ petitions. Also heard Mr. T.J. Mohanto, Learned Senior Counsel, assisted by Ms. P. Sharma, appearing for the APSC authorities. Mr. P. Nayak, Learned Standing Counsel, Finance Department, has appeared for the departmental authorities, whereas Mr. R. Sinha, Learned Counsel, is present on behalf of the private respondents. After hearing the arguments of Learned Counsel for both the sides at some length, this court is of the view that that an affidavit from the competent departmental authority indicating as to whether all the 57 vacancies of audit officers sought to be filled up in the current process arose before the end of the year 2017 as mandated by Rule 15 of the
recruitment rules.
of the recruitment rules, or any of these vacancies actually arose in the subsequent year, that is in 2018 and thereafter. Full stop. Since there is no specific indication of the said aspect of the matter in the pleadings available in record, the Secretary to the Government of Assam, Department of Finance, is granted 2 weeks' time to file an affidavit clarifying the aforesaid aspect of the matter. The affidavit will also specify as to the reason why initially only 32 vacancies were sought to be filled up, but the remaining vacancies were added at a later stage. That is,
After the examination was over.
later stage, after the last date of submission of applications for the application was received, were received. File that affidavit. We'll go by the rules.
Yes.
That is binding.
My lord will give a date
Yeah.
after 2 weeks.
Let the matter be listed again after 2 weeks as a fixed part of,
Yes.
fixed part of matters. Mr. Nayak, let me put things in perspective. Who did what, etc., these are subsidiary. You have to follow a rule which is framed by the department. The rule clearly says which vacancies you can consider. So the vacancies has to be of 2017 here. It may be the fact that sometimes deviation is permissible, but that has to be on proper reasoning. You cannot say that we are government, we can do anything. That cannot be the stand. So therefore you specify what it is. And also there is a judgment of the Supreme Court. You have seen this, Gajanan, Babulal, and so on. That judgment appears to be favoring them. So you have to distinguish it. Mr. Mohanta, we take it that APSC has done what they were asked to be.
Those who are qualified, we are sending.
The government will have to explain. Let them, Mr. Sinha, let them explain. Then we'll see. Then we'll see. What if we find that the petitioners don't have any case, then we may not even allow you to argue. We don't have any problem. Why conserve your energy today? When you knew that the matter is being adjourned, why are you opening your cards? Merely because you have done some homework yesterday. Don't do it. Hold your cards close to your hearts. When your time comes, you argue.